Hello, everybody. My name is Jim Kendzel, ASA Vice President of Advocacy, and welcome to today's webinar. On behalf of the American Supply Association, I welcome all of you. This presentation is being recorded and will be available on the ASA website in approximately 3 to 5 days from today. ASA originally provided a webinar on the new regulations in July of 2018 prior to the implementation of the regulations in August of 2018. Since that time, ASA has been contacted by members asking if we plan on holding another webinar on the subject. Based on the requests, we thought it was time to revisit the regulation and also look at what has been happening since its implementation. Sorry, folks, having a little trouble with the reactivity of the screen. I would like to take this opportunity to thank all of our supplier partners. Through their financial contributions, we are able to provide services to our ASA community, such as today's webinar, at no cost to the participants. We are thankful for their continued support of ASA and the critical mission we serve in advancing the PHCP and PVF wholesale distribution industry. Please note that you will be muted during the presentation. However, you will be able to ask questions by entering your questions into the chat area to the right of your screen. You should be able to see that where it says type messages here. And I will be looking for those questions at the end of the presentation to go over and hopefully be able to answer those. I would like to thank those who completed the survey that was sent out last week. The information you provided was very helpful. We have documented the questions you provided in the survey on slides later on in the presentation. If those questions are not answered during the presentation, we will be sure to address them at the end. We are fortunate today to have two presenters who are experts in both the legal aspects of Proposition 65, as well as having direct experience in the design and implementation of systems at the distribution level for compliance with the regulations. Judith Praitis is partner in Sidley's Los Angeles office, head of the Sidley West Coast Environmental Practice Group, and a global co-leader of the firm's environmental practice. And Judith has worked with us in the past on helping our members better understand Proposition 65, and we welcome her here today. In addition, one of our members, Randy Massey from the Ferguson Enterprise Group, is also with us. And Randy, in the past as well as today, will give us information on what Ferguson has done related to the regulation in building up their systems and coming into compliance with the regulations, and what they've learned since implementing those. And myself as the facilitator, and again, I'm Jim Kendzel, ASA VP of Advocacy. The agenda today will be simple. Judith will remind us and go through the regulations for us, as well as talk about lessons learned from the trenches. And Randy will talk about his experiences, and then we will be following that up with the QA and question and answer period from the survey questions we received, and finally open it up for any additional questions that you may have that maybe did not come out from the survey questions. As some reminders, what is being provided in this program is not legal advice. The information is based on the presenter's current knowledge of and experience with implementation of the regulations. Your legal counsel should be consulted when determining the best approach to take for your company. Well, Judith, I guess it's time to really go into the meat of the presentation, start talking about the regulations. The floor is yours.
Okay, thank you very much, Jim, and good morning and good afternoon to everyone. It's a pleasure to be here with you again after about a year. So, just to set the table on what we're talking about today, I wanted just to briefly review the status of the regulations, and most of you are familiar with Proposition 65, but I find it always helps to set out the basics. So, Proposition 65 is a consumer ballot initiative passed by California voters in 1986. It requires, among other things, persons who expose a person in California to one of 950 plus listed chemicals to provide a clear and reasonable warning prior to that exposure. There are different types of exposures that are regulated by the law. They are called environmental exposures. So if you have operations within the state of California, such as you run a manufacturing operation, you have transportation logistical operations, warehousing, you do demonstrations in the state of California where you're releasing chemicals, whether it's at trade shows or your core business requires you to go to your customers and use your chemicals. Those are all called environmental exposures, and Proposition 65 has a regime for the posting or other provision of environmental warnings. Most people see these warnings when, for example, you step off the jet bridge at LAX. You will see the Prop 65 warning that you're being exposed to all kinds of chemicals in jet engine exhaust or in jet fuel. So those are environmental exposures. Second, Prop 65 applies to chemical exposures in the workplace. So if you are a California employer, then you have employee disclosure obligations under Prop 65, which are incorporated into Cal OSHA. Most of the enforcement related to Prop 65 does not concern environmental exposures, although there's a fair amount of that. Residential buildings and hotels and parking garages, again, the jet bridge I mentioned on the airplane. So there's been some enforcement on area warnings, but nowhere nearly as much as the third category, consumer products, which I'll get to. And there's not been much enforcement against employers per se for workplace hazard exposures, primarily because most employers do adhere to Cal OSHA hazard communication standards, and so workers who work within a place of employment do get their Prop 65 warnings that way, or they get it through posting of signs. The major topic of enforcement are the consumer product warnings. Now, I will note that Prop 65 also has an anti-discharge prohibition, which is the reason it's called the Safe Drinking Water and Toxic Enforcement Act is that the law originally was intended to protect drinking water supplies from any one of these, what are now today 950 plus chemicals. The law provides that a person is prohibited from discharging these chemicals into a source of drinking water. Again, there is some enforcement of that provision, but unless those of you on the phone are conducting industrial operations in California and have releases of Prop 65 listed chemicals into the environment, and those releases can migrate either into surface waters or through groundwaters into sources of drinking water, you're not really going to have much contact with the anti-discharge prohibition and the drinking water protection provisions of Prop 65. So the big play, again, just to set the stage, is on consumer products. What is a consumer product? That is not well defined. It continues to be an issue of I know it when I see it. A 50-pound tote of a resin is not a consumer product. Glue sticks packaged in consumer-ready form, those are probably consumer products. You've got sort of industrial size quantities and 55-gallon drums of chemical products or cleaners. Those are not likely to be identified as consumer products. you've got 12-ounce packaging of the exact same product, that's probably a consumer product. So the nature of the product, the packaging of the product, the labeling of the product, the instructions for use, the intended application, all factor into whether an item is a consumer product. And I know many of you on the phone today do not manufacture consumer products. Rather, you manufacture components that other people use to make consumer products, or compound to make consumer products, or manufacture into consumer products. So you're providing intermediates or ingredients or components of consumer products, but not consumer products themselves. The Prop 65 consumer product warning regulations apply to consumer products and the person who creates that consumer product that the consumer actually handles. Another key point to remember is that Proposition 65 is an exposure trigger law. No exposure to the listed chemical, no duties. So again, it's important to remember that Prop 65 isn't triggered merely because of the presence of a listed chemical. Just because you can detect it doesn't mean you have to warn for it. And I know there's a lot of confusion around that point. And in fact, one of the lessons from the trenches we'll get to is that many people have given up trying to figure out whether there's an exposure, and simply determine if they can detect a listed chemical in their consumer product, they're simply going to warn because they don't want to bother with defending against a claim that a warning was required, or conducting the necessary scientific review and exposure assessment in determining whether a warning is required. But the law itself requires a warning prior to exposure. So again, when you don't have an exposure, you don't have a warning duty. What happened last year? What was all the hullabaloo? And there's been a lot of chaos and confusion since August 30th, 2018. On August 30th, 2018, the effective date for the new form warning Prop 65 regulations passed. And what that means is that from that date forward, for products manufactured on and after that date, on and after August 30th, 2018, those products are subject to the new safe harbor warning regime. So one of the major points of confusion has been that Proposition 65 as of August 30th, 2018, did not change whether to warn. It only changed how you warn once you've determined a warning is required, or you've elected to apply the warning because you don't want to incur the cost and headache of deciding whether to warn. Okay, so it's not a new warning obligation. The warning obligations didn't get broader. They didn't, expand to new categories. It's just how you deliver the warning is different than it was for products manufactured prior to that date. There is a sell-through, so for those people who have products in the stream of commerce and they have 2, 3, 4, 5 year shelf lives, if you had a warning that was legally compliant prior to August 30th of 2018 on that product, that warning remains legally compliant until that product is fully sold through. So these, again, are points of confusion and misinformation for folks. So I realize I'm kind of going through some of this slowly, but I want to emphasize some of the key issues where in the immediate 6 months after the new warning regime came online, there were a lot of questions. They've only tapered off really in the last month or so. So the other big thing, the other major development that occurred with those new warning regulations was that internet warnings are required for products sold via the internet and shipped into California or sold to a California consumer. Note that both are triggers under the safe harbor regulations. So if I'm a purchaser, resident here in California, I have a California zip code on my credit card when I plug it in, a California purchaser is entitled to receive the warning on a website or in connection with the website purchase. And if a California shipping address is designated as the destination for the product, it would be very prudent to advance a warning in that circumstance as well. Technically, the regulations require the warning to the purchaser, but we've counseled people to, one of the lessons learned from the trenches is to make sure that you get those warnings delivered to people who are shipping to California. So the internet warnings are duplicative. You still need to have warnings on the product. So that's another question that we often get. What happens if I warn on the internet, but I don't put any warnings on the product? Well, that may work, and there are some fact patterns where that will be legally sufficient, but there are a lot of fact patterns where it will not be. And the state of California, OEHA, who's the agency that administers Prop 65, they were very expressed that they wanted the internet warnings to be duplicative of other forms of warnings. Those other forms are on product, on store shelves, or on you can also put warnings on shipping papers and other means of ensuring the consumer sees it. Hang tags are allowed, but primarily on product or on label warnings, hang tags, as I said sometimes, and far less often warnings on store shelves. I know we have a question later about what do you do when people are buying bulk commodities or they select items like, say, from a bin or something like that, in which case a shelf warning may be appropriate if you can't put a warning on, every single little widget that's in a big bucket of widgets that people scoop out with a scoop, for example, or nails or thumbtacks or things like that. So with that baseline of reminder, what are the big lessons learned from the trenches? So I'll start again. A lot of confusion. Number 2, you really have to work to get your internet warnings up, because if people are buying your products via the internet and you're not providing the internet warning, then you're arguably not adhering to the safe harbor warning regime. If other people sell your products via their internet websites, then they have the duty to provide the warning if you've got a warning on your products. If you have consumer products, probably the single biggest lesson that I've seen people very reluctantly in some cases accept with resignation in other cases is that if your product needs a warning, if you've got some kind of, household cleanser or glue or a paint product or a resin or something, and it's a consumer product, really the safest place to put the warning is on the label. And if you don't put it on the label, there's a risk that that product ends up in California through your own website, through a third-party website, through eBay, through any kind of mechanism. And so one of the most important lessons that people are kind of faced with today is even when their internet can be programmed to provide warnings, and even when their downstream customers are selling via the internet, they've got the warnings up. If you don't have the warning on the product itself, your risks of enforcement go up. The second lesson learned, I would say, is that there has been a proliferation of warnings. Many of you have noted this and asked about it, and when you come to California, you'll see there are warnings on everything. One of the unintended consequences of the new warning regime is that everybody slapped warnings on everything. Now, of course, that's not literally true, but an important lesson has been that once you updated the warning regulations, a lot more people decided to warn because they're being precautionary, not because they actually think the warnings are needed. So aside from having to put warnings on the labels, a lot of people have simply decided that they would prefer to warn, and given there are 2 ways to warn, there's a long form warning and a short form warning. The short form warning is just an equilateral triangle and it says cancer, and then a website or cancer and reproductive harm, and then the website address. Some people find that those don't look too scary. They put them on their products and they have just checked out of the rest of the regulatory regime. So a second lesson is that there's a lot of precautionary warning going on, because what has happened? Well, there's been an explosion of enforcement. Last year, there were over 2,000 citizen notice of intent to sue letters filed against every product imaginable under the sun. And if you go back 5, 6, 7 years, those numbers were maybe 300, 400 notice of violation letters a year, and we're over 2,000. This year, we're on pace to be probably above 2,500. So the plaintiff's bar has multiplied. And so what people have learned is that if you have chemicals present in your product, although you don't have to warn because of the mere presence, if you want to avoid the risk of litigation, you put on the warning on the product somewhere or attached to the product somehow. Sometimes products are sold loosely and you can't literally put the warning on the product. Another lesson that I think has arisen is that most people have come to realize that imperfect warnings or over warning, which is what we call people who warn on a precautionary basis, not because they've concluded a warning is needed, those types of warnings are safer than not warning at all if litigation avoidance is your primary concern. Consumers have noticed, but often our experience is that calls or questions come from consumers outside of the state of California. So you might get calls on your 1-800 product numbers asking, what is this? What does this mean? Why is it there? Californians are pretty jaded. I would say, most recently after the coffee trial, wherein a judge ruled that coffee, when served at coffee shops like your Starbucks or Pete's or Seattle's Best Coffee or, Coffee Bean and Tea Leaf, pick your brand. I'm not mentioning any specific brand to say their coffee is different. But a judge ruled that acrylamide in coffee requires a warning. The state turned around and said, no, it doesn't. The science doesn't support that, and we think it would be wrong for consumers to be misled. And so regulations were adopted. They were adopted, then withdrawn, and now they're reinstated again. Essentially, OEHA, the state, overruling the judge saying you got the science wrong, which infuriated the judge, and the whole trial is still ongoing in a mess. That was all very highly publicized. So one of the lessons learned, in part because of the new warning regime and in part because of high-profile cases like the coffee trial, is that people are less sensitive to these warnings now. They just don't matter as much. It is true that there are still certain products, probably not so many of those that you all advance, but with respect to foods, with respect to certain types of children's products, people are still sensitive over the warnings. Some personal care products, people don't like warnings on certain types of products applied directly to the body or ingested. So there's still some play and some fighting on some things, but your garden variety products carry a lot of warnings now, and people don't seem to be reacting so adversely to them. So that's another interesting lesson I think we've learned. And then I'll maybe put out one more, and then Jim, if it's okay, we can transition and then go back to questions, as you prefer. But the last major source of confusion where we've had a lot of difficulty dealing with people is something which I think is important to those of you on the phone, which is who has to do the warnings along the whole product supply chain? And can people give up their obligation up and down the supply chain to provide warnings? So Prop 65-101 says that everybody in the stream of commerce, everybody in the product supply chain is liable to provide a warning. The importer, the manufacturer, the distributor, the retail seller. Everybody has a legal duty to warn. The primary duty is on the manufacturer. That's the primary duty. But again, if the manufacturer fails to warn, Prop 65 plaintiffs can sue an importer, they can sue a distributor, and they frequently sue retailers because, of course, retailers are the people from whom they acquire the products and they can be found. So retailers like Amazon and Walmart, TJ Maxx, Nordstrom's, Macy's, Walgreens, you name it, they get Prop 65 notice letters pretty much every day, and multiples every day. But those retailers always push back upstream to the extent they can to the manufacturer or the distributor or the importer. So everybody has the duty to warn, primary duty on the manufacturer. The new regulations provided for a mechanism by which a manufacturer, for example, in other words, a person upstream in the product supply chain, could completely divest itself of its obligation to warn by passing along that warning duty to persons downstream in the supply chain. And we have had several clients encounter that effort, particularly by European manufacturers. And I'll give you a classic example where I've seen it more than once, like sunglasses. These are often luxury goods sunglasses, $300 sunglasses, those sorts of things. And the sunglass manufacturers will say, we understand under this law that we've got to tell you that a warning is needed on these products, and we're selling you these products. Here's the warning materials, and they include some number of stickers, or they'll say, here, go to this website and print out these stickers. And if you sell these products in California, you put these stickers on these sunglasses. Or if you sell these products in California, here are a bunch of shelf signs. You put the warning shelf signs up in those areas where you sell your sunglasses. Okay? And, good luck. So the regulations actually provide for that kind of a transfer of the warning obligation if and only if the upstream person executes this transfer perfectly. And I will submit for you the observation that nobody in this world is perfect. Very few things in this world are perfect. So what happens is the upstream people don't actually transmit the obligations perfectly, but more importantly, the downstream person who receives this information just rejects it. They're like, no, we will not apply these warnings. You got to put warnings on products. We will not devote staff time. We will not take the legal responsibility for trying to figure out if shelf signs are adequate or not, or if somebody moves them around, or what happens when the sunglasses get moved to the bargain bin and they're no longer next to a shelf warning. We're not going to take that responsibility. We refuse it. We reject it. We're not going to sell your products anymore. Now, does that always work? Maybe yes, maybe no. What I can tell you what will happen is if a plaintiff, sticking with the sunglasses example, would buy sunglasses and determines they contain BPA, which is the main chemical at issue in sunglasses, they will issue an NOV to the retailer, who will turn around and push right back upstream and demand indemnification. And then you get kind of potentially a messy situation as to who really has the legal responsibility to warn when the manufacturer thinks they've discharged their duty, but it turns out maybe they didn't do it perfectly, and they didn't follow up, and they didn't do this and didn't do that. It's kind of like going through a maze, and if they didn't go through the maze properly, they didn't properly transfer the duty, meaning they stay liable. So I know that took a little bit of explanation to lay out on the table, but I think it's important for your group because you do have products that pass through multiple persons in the distribution supply chain. Not every one of those points in time actually triggers a warning duty. So if you're selling bulk chemicals, which somebody then uses to make another product, you don't have the warning duty when you're selling a commercial product to another business. But when that consumer product is created, the first person who creates the consumer product who has the duty, and technically they can push that duty downstream. The reality is there are no distributors and retailers who will accept it. They get angry. You have, commercial contractual problems, and there is an effort on the part of OEHA to try to clarify that particular section of the regulations because, again, it's led to a lot of confusion, and a lot of people are very unhappy with that provision. The retailers hate it because they don't want to do the warnings, and the manufacturers are upset because they thought they didn't have to warn on every single product, and now it turns out they might have to do that after all. So let me stop there. That's probably the most dysfunctional section of the new warning regs. Jim, should we go on? Or, I can continue, but I want to be sure that we have plenty of time for the rest of the program and especially the distributor experiences.
Well, Judith, why don't we go? Why don't we switch over to Randy and have Randy talk a little bit about his experiences, and then if there's additional things you would like to say after that, Judith, before we get to the actual Q&A, why don't we take that process? Make sense?
Yes.
So with that, Randy, I'm going to turn it over to you and talk about some of your experiences and maybe talk a little bit about what you did to comply with the regulations and what you've learned over the last year or so related to that. So the floor is yours, Randy.
All right, sounds good. Thanks, Jim, and thanks, Judith. Again, I'm Randy Massey, the Senior Manager of Product Quality and Compliance at Ferguson Enterprises. I'll hit the implementation of what we did for Prop 65, talk about some of our experiences, and at the end, also hit some of the challenges that we dealt with. So my department, we work with various departments when they're within our organization to make the Prop 65 project happen. We worked with legal, first of all, IT or e-business, sourcing, product services, and various other business groups that support our customers. First of all, assisting me on this project was Jesus Moreno. He's my project coordinator, but he's our manager of product and vendor compliance. So Jesus and I met with legal multiple times, legal counsel internal and external to the company to better understand the changes to the law that were going into effect on August the 30th of 2018. Many times as we were looking at the law and the changes, we were questioning the intent of the lawmakers and what would be an effective implementation. This was a new addition to the laws, as Judith already stated, and it certainly was subject to interpretation as was previously stated in the PowerPoint. Once we worked multiple times with legal, we developed various strategies to properly warn our customers via the various channels that we sell to our customers in California. Could be over our counter or via delivery out of our showrooms or online via one of our e-business websites. So once we developed those strategies, we start working with our IT department internally. We had a lot of associates in our IT department working on this project. We kind of phased it out into two separate phases. Phase one was about educating the IT team and department on the new changes to the Prop 65 law and what we needed to be compliant. So that took some time to get an understanding of that. Then that team did the build out of the attributes to the Prop 65 warnings in our master product data files. This was a very significant part of the project, very important, but took a significant amount of work to get that build out done. Phase two within IT was about collecting the warnings, loading them into the master data management system, and then building out the IT solution and the various ERP platforms and business channels that Ferguson utilizes today. Then the IT department did various testing of the systems to make sure that the customers would get warned at the appropriate times. Also to note, it was very important that we got an early start on this project due to the overall complexity. We started about a year and a half before the August 30th date on a lot of these phases of this project. Next, very important, was vendors and products. We had many written communication that went out to our vendor partners about the changes to the Prop 65 law. We did put quite a bit of pressure on our branded vendors that they needed to understand the law, interpret the law, and that they needed to properly mark their products to meet the changes to the law. Where we did do many one-off conference calls with key vendors to discuss their research and strategy around being Prop 65 compliant. We tried to steer clear from giving them advice, but we did share information where we could, because I think a lot of times it helps to share ideas with something new like this. Very important was that we did push very hard that the new product warnings had to be on the boxes for anything produced after the August 29th date of 2018. Further, working with the vendors, it was getting the data back from them, collecting the warnings from those vendors. Not only did they need to mark it on the boxes that but that we need to get those warnings so that if we're selling that product online, that we've got that exact warning that the manufacturer is using, and then we want to load that in our system so that at the appropriate time, those California customers, as Judith said, either a customer that resides in California or is a ship-to address in California, that they would see those warnings on the IT online websites prior to checking out of the box. Also within IT, it was just running testing to make sure that all the warnings were properly displayed at the right time. I kind of said that previously, but that was a very important part of the IT project. Some of the challenges that we saw with the overall project was identifying the items that they needed a warning. Oftentimes this was difficult. We had a wide variety of understanding from vendors. We had vendors that had been providing warnings for many years, and we had other vendors that seemed to have never heard of this law before, which kind of surprised us. So a lot of vendors did not have warnings. Some of them were doing testing. Some of them didn't do any testing. As Judith said, some just decided to put warnings on products because they were not sure. But I had a wide variety of information coming back from vendors in that respect. One of the big challenges for us is previously stated multiple times last year and again this year is this product sold in bulk. Quite common in the plumbing mechanical industry. We have products that are sold in master cartons and then boxes. So those master cartons and boxes oftentimes would have the warning, but then the individual product may not have the warning. So the solution there, as Judith kind of previously stated, is duplicating the warning. We would put the warning on the counter bin, and then also have a warning that prints out on our shipping tickets to our customers along with the invoices that the customers ultimately get in the mail. Other big challenges for us were dealing with overseas vendors who are not familiar with California Prop 65. Bringing them up to speed with the law, getting warnings on those products, getting the proper warnings on the packages. It's challenging oftentimes when you're dealing with language barriers. So that was definitely a challenge for us. But with that, Jim, that's kind of the end. Kind of hit implementation experiences and challenges. Kind of very similar to what we talked about last year. But that's it for me.
Thank you, Randy and Judith. I think both of your presentations and the challenges that people are running into and you personally have run into with the implementation have been very insightful and helpful. I think the things that jump out at me, that jumped out in our presentation last year as well as this presentation, and I'm still not sure if our supply chain members are fully aware of it. And by the way, we have, based on the survey results, about 70% of the folks on the call are in the wholesale distribution end, and about 30% of those on the call are on the manufacturing end. So we have a good representation from both sides of the supply chain, or the two ends of the supply chain, however you want to look at it. And so I think the thing that jumps out at me is, and continues to jump out, and a concern I have that maybe the industry isn't fully aware of, is what Judith brought up related to the internet sales of products. And a lot of our wholesale distributor members are doing internet sales as well as product manufacturers. And no matter where you're located in the country, if someone is in California is purchasing something from you on the internet, you now have to be aware of and cognizant of the requirements of Proposition 65 and the labeling requirements. And so that's a message I continue to try to get out there and make sure everybody's aware of. And the other piece Randy brought up is the concept of the packages come from the manufacturer, they're properly labeled, and of course the wholesale distributor takes them out of the larger package, and now what do? And so Randy covered that as well. So thank you both for that. I think it's very helpful. And so I think, why don't we go into the questions that we received from those who completed the survey? And I think that'll get us into a little more detail and depth of the subject as well. As we go through the questions, I will read each one and then indicate If I believe it was answered during either Judith or Randy's presentation, I'll indicate so and then offer Judith and Randy the opportunity to maybe further talk about that or not. And if we haven't even addressed it, I'll be asking Judith to take a shot at it and have Randy jump in as we go along. So let's see how this goes.
Oh, and Jim, it's Judith here.
Yeah.
If I could comment on Randy's very insightful presentation, because
you may.
what he described is a process that many have had to go through, and there was no shortcut. It was just hard, and especially getting all the warnings from people and getting your systems programmed. Some people somehow think that they're doing things incorrectly, or they're bogged down, or this can't be what we have to do, and they get kind of frustrated and annoyed. But the reality is, it is a frustrating and annoying process. And what Randy described is what people who have had to do this properly have gone through. So misery loves company, but it is worth noting that these regulations are not really written for the modern, complicated global supply chain. They're cumbersome, they're clunky, and they're painful. So what he described is really kind of a best practices approach to what they did, what needs to be done. The second really important point, I think, that Randy brought up that I'm really glad he did, because it really bears highlighting, which is the regulations are kind of set up, not in so many words, but in actual effect, that if one person in the product supply chain receives a warning, but doesn't pass that warning along, they might get held liable for the failure to provide the warning when that product ultimately gets into a consumer's hands. And it's not always feasible to pass a warning along. And as I described in my Lessons from the Trenches section, there are lots of examples where somebody upstream, especially a manufacturer, especially a non-U.S. manufacturer, is trying to unload the entire warning duty down the stream of commerce, and then people want to reject that. But you have to be careful, because if somebody gives you a warning and you don't pass it along, and you don't talk to the person about, hey, you have to put this on the product, we're not going to engage in stickering and doing these things for you, you might then be in breach of your contractual obligations to people downstream. And so this has been a very sore point, that if you're given notice of a warning, you've got to figure out some way to pass it along. And what Randy described, for example, including it on your invoices when you can't, when you have a bulk good and it comes out of a bin or a big pack or something like that, and you don't have individual units labeled, is an excellent solution. It's not a safe harbor form, but it is a practical reality that Randy and other folks have crafted that work for their business. So you don't have to just rigidly adhere to the safe harbor warning regime. But above all, I wanted just to highlight that what you described there was really kind of a case study and a best approach of getting through this onerous task.
Thank you for that, Judith. And I think you're absolutely right. And the other members of ASA that I have spoken to about this would highlight what you said. It's not easy, and it does take time, and it is cumbersome, but it's important to do. So thank you for that, for highlighting that. So let's take a look at the questions. I think in this first question, I purposely put at the beginning of the question section, because I think it really is the ultimate question that comes out, is who ultimately has the responsibility. And I think both Judith and Randy have covered this question. So I will ask either of you if you have anything to add to this question, or something you want to emphasize before we go to the next question. The question is distributor versus manufacturer. Who ultimately has the responsibility?
I think it's
everybody in the chain. Yeah, it's everybody in the chain. Everybody in the chain has the legal duty. Sorry, Randy, and you were going to say the manufacturer has the primary duty.
Yeah, but we're still in there, so we know we've got to do it as well.
Yep. So I think the summary of that is everybody. Everybody's involved. Second question is, do the requirements for labeling differ if the customer in California is using the materials for MRO rather than for OEM production? I think we sort of covered this in various ways. So I'm going to ask Randy if he has anything to add to this based on the industry acronyms and what they mean to the distributors. If you have any thoughts on this.
Yeah, we talked about this briefly the other day with Judith, and I think they're getting at the consumer products piece of the law. So OEM's original equipment manufacturer, MRO is maintenance repair operations. I think as Judith stated earlier, there are certain products based on their packaging that could be considered consumer products or not consumer products. So I think it's subject to interpretation, so you've got to be careful there. She had some great examples at the very beginning of the presentation that kind of highlight this. So you could have a particular product just based on the packaging. It's a 55-gallon barrel of chemicals. It's an industrial product. A consumer can't buy it. But if it's in a 4-ounce package and you can buy it on your counter, it's probably a consumer product. So I think that's kind of what they're getting at with that question.
Okay, thanks, Randy. Judith, anything to add?
Nope. I think Randy described it well.
Okay, Judith, I'm going to give you a softball question. Do imported products to California companies have to comply with the same labeling requirements?
Yes, the law expressly applies to importers, manufacturers, distributors, and retailers. Now, where this question gets a little tricky is when you have offshore manufacturers who aren't subject to being sued under Prop 65 because they have no operations here, they have no bank accounts here where you can get a judgment against them. So sometimes those folks feel like they can ignore the law because, of course, the retailers can be sued, but the manufacturer cannot be. What usually happens in those circumstances is that the retailer or the importer of record or the distributor, whoever it is the plaintiff can sue, they will sue. And whoever it is that gets sued will be forced to resolve the matter and then try to seek recoupment of their defense and settlement costs from the ultimate, person upstream who really was responsible for the failure to warn. Sometimes that works, sometimes it doesn't. We have clients who have a lot of manufacturing abroad, especially in China and Vietnam, and they get hit with these Prop 65 lawsuits, and sometimes they can recoup their costs from their suppliers in China as a business matter, and sometimes they're left holding the full ticket. So it is a factor, in further vetting who you do business with and whether you can rely on their test results and information, because legally the duty applies to everybody, but if a plaintiff can't sue, they'll skip over whoever it is they can't sue. Again, many of them are going for the easy money and the easy targets.
Thank you, Judith. The next question is really asking, are any of us aware of any PVF, industrial piping, fittings, valves market? Are any distributors basically just refusing to sell in California because of the law? The person asking the question mentions gun manufacturers have apparently taken this approach. So I'll leave it open to Judith or Randy, and let's go with Randy first. Have you heard of anybody in our industry who has just said, nope, I'm not going to sell in California due to this?
No, I have not. We certainly sell in that category in the state, but I've not heard of any manufacturers or master distributors that are not selling in California. I did just see where Academy Sporting Goods, headquartered in Texas, had a notice on their website that they're not selling in California. So I think what they're saying is correct on guns and other sporting goods, but in our category, I've not seen that to date.
Okay. I will
I
put it
think
out there for anybody who's on the call, and Judith, I'll get to you in a second, but if anybody's on the call, if you are aware of or have an example of the PVF or the plumbing industry distributors who are manufacturers even refusing to sell in California on this, go ahead and type that into the chat room. Judith, did you have something to add?
The issue of trying to keep your products out of California, refusing to sell in California, can be tricky. The answer is yes, there have been probably at this point thousands of products that have either been eliminated, people just won't sell the product again, or reformulated into something entirely new over the lifespan of Prop 65. And yes, there are a number of companies that outright will not sell into California. The difficulty arises with modern distribution chains and complexities is those products end up in California anyway, because somebody buys them in bulk somewhere else, and then they get sold off of a website based, in Texas, and the order's fulfilled from a warehouse in Arizona or whatever, and the product ends up here. So it's very difficult to avoid California unless you have, perhaps with guns, you have tight enough control of your inventory. The second question that often arises here is, well, can't I just slap this not for sale in California, or do not sell in California, or prohibited for sale in California? Can I put that on the label, and isn't that going to protect me? And people have tried that. I've not seen anybody try it in recent years. Maybe over the last decade, maybe we'd get a different outcome. Historically, that doesn't work. If the item ends up in California, the manufacturer is still responsible for having to provide a Prop 65 warning, even if they didn't intend for the product to get there, unless it's a consequence of mistake or accident, and there really was absolutely no knowledge that it could get there. So it's not sufficient to say, okay, well, I just sold to my customers in North Carolina. I didn't sell to California. In fact, I told them not to sell to California. That simple two-step process will not get you out of a Prop 65 lawsuit. You've got to do more than that to protect your products from entry into the state, in which case you might be successful.
Good information. Thank you, Judith. The next question, Judith, I know that you covered this early on in your presentation, which is related to what the basic question and statement is, with the new requirements intended to help clarify and eliminate confusion, why does it appear that so many manufacturers are now labeling their products when the exposure details remain unclear? And Judith, I know you touched on this earlier. Just do you have anything else to add to that or reemphasize?
Well, I mentioned confusion and chaos. Probably frustration is the next word in the order of responses to Prop 65. People are just, or maybe fed up. They're just frustrated and fed up, and they've just thrown in the towel, and they said, look, if this is what it takes to avoid lawsuits, that's what I'm going to do. It's probably a wave that's crested now, and over time that wave will subside as people forget about it. But the enforcement is robust, and there are thousands of people who get these NOVs every year. So, as I said, some people have just gotten fed up, and they just put the warnings on, including on commercial products. I have seen examples of major chemical companies and major electronics companies, even when they're selling commercial products, B2B, including Proposition 65 warnings, just precautionary because they don't want to run afoul of the law. I know, Randy, if you saw the same thing in your experience in developing your whole warning program.
I think we've seen some products, Judith, that I mentioned earlier, that are kind of right on the line of being commercial, but they could be available for sale in a retail environment, or where someone could actually access them on a counter. So some of those are right on the bubble. I have seen some in that space, as you mentioned. I haven't seen any along the lines of what you're talking about, like a large piece of commercial equipment or anything like that. But I've not seen that.
All right, let's look at the next question. And it is basically, is there anything preventing a company of simply putting Prop 65 labels on everything to make, regardless of whether or not it has a Prop 65 chemical? Again, I think this is sort of a different look at the previous question, but maybe not. So Judith, I'll throw it out to you to see if this pops up anything else in your thought process or giving an answer.
Sure. So one of the accusations that OEHA and the Office of the Attorney General being the chief law enforcement officer of this law, they take great umbrage that Prop 65 prompts a bunch of meaningless warnings, and overwarning is something they profess to abhor, and they really get upset when you accuse them of creating regulations, promoting policies that result in overwarning, which we've just talked about these new regulations have done. There's no question that they've resulted in a massive proliferation of overwarning, as well as probably an uptick in, proper warnings. So what's the state doing about this so-called policy position that they don't want overwarnings? They want clear and reasonable warnings, which is the legal standard. They don't want overwarning. So OEHA has essentially investigatory and subpoena authority in regulations now, where they can actually contact manufacturers, distributors, and retailers, although they tend to avoid retailers unless it's a private label product. And they can contact them and demand information as to why a particular warning is on a particular product. What's the basis for this? And they have legal authority to ask those questions, and I haven't seen anybody really want to challenge it yet. I have my own views as to whether you actually have to respond to that. So it's essentially an investigation subpoena, but they are starting to use that subpoena authority in an effort to prevent reflexive and massive overwarning. But the bottom line is, if you were to ask me, Judith, how many people have gotten in trouble, some kind of trouble, because it's not clear what the Attorney General could do. Could they order you to take the warning off? It's not clear they could order anybody to take a warning off a product. So how many people have been sued for overwarning or stuck in a legal limbo, or at least a legal proceeding with respect to an improper warning or anything like that, versus how many people get sued every year for not warning? Well, again, last year there were 2,000 plus NOVs, notice of violations, for people who did not warn. I'm not aware of any proceedings thus far against people who overwarned or who warned improperly. Historically, there were some improper warning lawsuits, but there haven't been very many of those, again, in juxtaposition to the tens of thousands by now of cases brought for a failure to warn. So, there are theories that you can be sued under the Business and Professions Code by the Office of the Attorney General for false and fraudulent information. And if you have no listed chemical anywhere in the product, maybe you'd lose that case. But that's not tested. If the chemical is detectable, then you can warn and argue you simply decided not to assert any affirmative defenses. So I'd be a little bit careful if you have no listed chemicals detectable, because in theory, it's possible the Attorney General or some other prosecutor can argue that you're conveying a fraudulent statement to the consumer. But I'm not even sure they would do that. I'm not sure they would win. I'm not sure that's the argument they would make. It's a bit of a gray area.
Okay, we are getting very, very close to the end of our time slot. So I'm going to ask for see if we can give some very quick responses to some of these remaining questions if possible. But let's look at the first one. We use short form warnings on our packaging. Is that sufficient? Judith?
If you're using the warning properly and the packaging is directly consumer packaging, not bulk packaging, then again, you've got to have the warning on each individual consumer unit, not just on the shipping box or a shipping crate. because that won't get to the consumer. The consumer needs to see the warning.
Okay. The next one is primary market is in 2/3 of the state of Kansas. We have our catalog on the website. Is it important that we label items on our catalog? I would think the answer would be if those products can be sold or purchased from somebody in California, the answer is yes. Judith?
That's right.
Am I
There
correct?
are new. You are correct. There are new rules on catalog warnings, which everyone's kind of forgotten about because people forget about catalogs. So you have to be careful that if you are selling via catalog and you have California purchasers, that you are complying with the catalog warnings. In the alternative, again, I go back to something I said at the top of the hour, and something that Randy also emphasized is if you've got the warning on the product, that will trump. You will be compliant if that warning is on the product or the immediate consumer product packaging label. So
Good point.
Safe Harbor says you got to warn on the catalog as well, but the key is to make sure you've got that warning on the product or on the label of the product. That will comply if it's a proper warning.
Randy, I'm going to toss this one to you because I think you have some examples of how companies handling the labeling and self-serve products in counter areas.
Sure. So we're putting warnings on our tickets, Jim. Those warnings would also be on the packages. Again, if it's a bulk product, there would be a warning on the bin, that they would see the warning on the bin, but they would also get a warning on the ticket as they are signing the ticket at the counter. And that's it.
Judith, any other examples from your end or things you have seen that you want to share with the folks?
No, that's a common approach. Sometimes you've got to use invoice or receipt warnings as a backup to a shelf warning or a supplement.
Judith, the next question talks about enforcement, and I think you actually brought that up, and if I understood it correctly, enforcement has actually gone up, or the number of cases. Did I hear that correctly?
Through the roof, and it continues to climb.
Yep.
And the money amounts are growing as well per case. The average case resolution sums are going up as well.
And then finally, does each item have to be labeled or just a category?
Randy, does that question make sense to you in the industry more? Because I'm not sure I'm understanding the question.
Yeah, it's each product. So if it was steel pipe similar, but you still got to label each product. So if you're, the sticker's either got to be on the piece of pipe or it's got to be on the individual size. But I think you can categorize a category. Hey, these are all black malleable fittings and they need a warning. But each individual SKU is going to need its own warning at the bin label, if it's a bulk, or if it's on the product packaging. But I think they're just trying to categorize products into a product category. But yeah, you've got to have the specific warning we did it down to the SKU level. So that's my understanding.
Yeah, I think that makes sense. Yeah, I'm not sure I understand the question well, but I agree with what Randy said as assuming we are understanding the question.
All right, I have no additional questions that anybody has entered, so I am going to, and we need to wrap this up. So, Judith, I'm going to offer you, and then Randy, you any closing thoughts you'd like to leave the group with as we close out the webinar?
No, it's my pleasure to participate, and I hope you all found this useful and got a little bit of sense of solidarity that you're not alone in dealing with these vexing issues.
And I'll just say
closing thoughts from you. Oh,
sure. I appreciate Judith sharing her legal expertise in this area. Very helpful. Definitely learned some things from her today. I think it's something that you continue to learn about, but you just gotta. It's a law that you've got to stay up to date on, and you've got to do your due diligence and make sure that your vendors are also doing the right thing. So it's something you've got to constantly be watching and just monitoring what's going on in California for sure. If you're going to sell in that market, you've got to abide by the laws in that state. So thank you for inviting me, Jim.
Thank you both for providing, again, an excellent webinar, and you both have, I believe, created great value for those who participated in it. For those on the call, you'll see here Judith's information, and if you go to this link on the website, you'll get to see what Judith looks like and also get to know her a little bit better, and also her email address, and maybe reach out to her. You can reach out to me at any time at jkendzel@asa.net, and if I can't help you, I will do everything I can to find an individual or individuals who can help you on this particular subject. And finally, as mentioned earlier, this presentation has been recorded and will be available on the ASA website. And it will be also on that website. We currently have several resources, including some papers that Judith has written, white papers on the subject. So you can go to that web section of our website and get additional information on Proposition 65. So with that, I will close out the webinar, and thanks Judith and Randy for participating and helping us out with this. And thanks everyone for attending. Have a great day.
Bye.
Thanks, Jim.